going to talk about space property rights. There's been a lot of interesting things going on with legislation, and I'm sure the panelists will cover that in this panel. And to moderate this panel is Professor Matthew Schaefer. He's the Director of Space and Telecom Law Program at the University of Nebraska-Lincoln, and he's been teaching for 19 years in topics including international law, foreign affairs, national security, and international trade areas. He's also served on the National Security Council as director in the International Economic Affairs Office. Please help me in welcoming Professor Matthew Schaefer. Or, sorry, you'll be sitting there.
Thank you, Curtis. Thank you, Curtis, and good morning to everybody. Great panel here today to talk about space property rights and something connected with that, on-orbit jurisdiction issues that some of you may know about. We have a great panel. Sagi Kafir, Corporate Counsel, Deep Space Industries. Prior to that, Corporate Counsel in the aviation industry for many, many years. Jim Muncie, who all of you know, co-founder of the Space Frontier Foundation, also founder and principal of Polyspace. And via Skype, we have Baron Zoka, founder and president of Tech Freedom, and also who currently sits on the FAA's ComStat, Commercial Space Transportation Advisory Committee. So this is a topic that is stirring around DC, and we'll talk about some recent developments that are even bringing this more to the forefront. First two questions we're going to go through today. First one's going to deal with extracted resources. Do companies have property rights over extracted resources? Second question we're going to cover is, can companies have property rights, or at least non-interference rights, or zones of safety when it comes to the surface and subsurface of lunar bodies and asteroids? And I'm going to turn first to Jim, who has a chart for us on a recent bill that was introduced by Representative Posey from Florida and called the Asteroids Act. So Jim, I'm going to turn to you just to give everybody lay of the land on this recent legislation introduced by Representative Posey, and then we'll turn to those two questions. Jim?
Not accused of needing one. First of all, I'm the only person on the panel who is not an attorney. As a former congressional staffer and an evil lobbyist, I write laws, but I cannot give you an official opinion about what they mean. So I can't practice law counsel. We thought it would be interesting to talk about the fact that there's been this discussion of property rights going on in Washington for a while, and certainly broader than just in Washington, but this year, just a few weeks ago, Congressman Posey, who's a senior member of the House Science Committee from Florida, from the Space Coast, along with Derek Helmer, who's a younger member from Washington State, introduced a bill which they spent a long time crafting, all year, frankly, crafting and working out, as sort of a seed crystal in this supersaturated solution. And it's tripping over, they designed it to not cause too many explosions, or conflicts or problems. But even so, because there's now something to talk about, something concrete, a lot of discussion is starting about it. And so we thought it would be a useful thing to start with here. So first of all, the thing is that they crafted the bill. It doesn't use necessarily all the words we might expect a bill on space property rights to use, but a lot of the language in the bill is specifically crafted to stay within the jurisdiction of the House Science, Space, and Technology Committee. Procedurally, if you have a bill that is referred to multiple committees, you have to convince multiple committees to actually hold hearings, mark up the bill, and pass the bill for it to get through the House of Representatives. And that's a more Herculean political effort than just doing it with one committee. Also, they actually discussed this legislation in some detail, the members who sponsored it, with State Department folks, not to get their approval, not to get their blessings. Obviously, there's no endorsement by the administration for the legislation, but to find out whether or not it would be a big problem for current U.S. international obligations and policy and things like that. And one of the reasons why the bill only deals with asteroid resources as opposed to, I don't know, the moon or Titan or other useful places in the solar system that have resources is because they were trying to work things through and do things that would be least upsetting to the administration. So if you could go to the next chart. So this is just a quick summary of what it does. It directs the president to, encourage exploration and utilization, to discourage barriers to industry emerging. It promotes the right to explore, tells the president to promote the right to explore and utilize and transfer and sell resources that you obtain. And it says that you're supposed to develop a framework for encouraging all this that meets international obligations. So basically, it passes the buck in lots of important details. It says, Mr. President, go set up a regime, an administrative regime, a legal regime, whatever, to enable space property rights for asteroidal resources, okay? But it sets up part of the regime or some major cornerstones of the regime itself, what you might call framework key issues. One is that it explicitly confirms the Apollo precedent, where we brought back moon rocks, they brought back moon rocks, and we traded our moon rocks to them, and they traded moon rocks to us, and we all acknowledged each other's ownership of the moon rocks we brought back. So the idea is if you obtain resources in outer space, they are your property consistent with federal law. So it explicitly affirms that. It sets the very important principle of freedom from harmful interference, and then it sets up a legal regime, says that you have a right to legal relief from that interference, and that the only court of jurisdiction for determining cases, legal claims based on such interference is U.S. federal district court. So it takes it out of the state's hands. It takes it out of, you can't do forum shopping. It's going to be a federal case, and presumably the president will have set up this, more detailed regime that determines how such cases would be brought. And that's it. That's what it does. It basically leaves most of the details to the president and the administration to go set up the specifics, but it has these big pieces are predetermined. And that's all it does.
Thank you, Jim, for the great overview. And so we're going to turn to the first question, extracted resources. Is it clear enough that companies own the extracted resources they bring back to Earth, or I guess even extract for use in space? Do you sense a debate over this? And in other words, if we look at Representative Posey's asteroids bill, that first legal provision Jim mentioned, it gives a property right for extracted resources to those companies. So Sagi, I'm going to turn to you on that question. Is it clear enough?
When you were asking that question, I just had this this flash of NewSpace's version of Orange is the New Black, right? We have Jeff Notkin from the Science Channel, from the Meteorite Men, who usually sell meteorites right outside, being led in handcuffs and being arrested for selling extraterrestrial resources, and led to the International Court of Justice, pleading in front of the judge, saying, "But Your Honor, I thought they were pretty-looking rocks." Yeah, I think it's pretty clear that we know that extraterrestrial resources in the form of at least meteorites are allowed to be bought and sold. We know that from all the sales of the meteorites on eBay. We know, as Jim was talking about, the Americans and the Russians swapping lunar regolith, and the second that, I think it was Russia that sold it for, what was it, like $2.2 million a gram of lunar regolith. I don't think anyone said anything since then in terms of crying foul. I guess the real question is it legal for private entities to extract extraterrestrial resources and sell them for a profit? And the bigger question is, what is the space property rights regime, right? I mean, where do we stand on space property rights in general? And I think, at least for many of us here, there are a lot of sophisticated people in the audience, and I think for many of them, they generally understand it. But even within the sophisticated audience, even within space attorneys, there are all these questions of what's legal in terms of property rights. So we obviously know that the Outer Space Treaty in Article 1 implores us to explore and use space. It says use space. But then at the same time, we have Article 2 that says no national appropriation of any celestial body, right? So we have those two issues. And then you have Article 8, I believe, that says all objects in space belong to the state, the launching state. So we know that we have a basis in the Outer Space Treaty. Well, then you throw in the Moon Treaty, right? And then you sprinkle that with a little bit of common heritage of man, and all of a sudden you've got confusion, right, in terms of property rights. So I think that in 30 plus years of academia and space attorneys talking about space property rights, there's been a confusion. They've put the entire topic in this orbit of confusion that's going to take a little bit of energy to redirect. And I guess the first important thing to do that, to really focus on space property rights and what's legal and what's not, is the critical issue of redirecting, refocusing, and compartmentalizing the entire space property rights issue between real property, land property, and personal property. Because when you have those two issues together, it confuses the entire subject. So we know that you can't, Article 2 says, no nation can appropriate celestial bodies. That's very clear. No one's going to argue that. Maybe some scholars will even say that applies to non-government entities. But at the same time, we know that we can use and explore space. We also know through the International Space Station agreements that personal property belongs to the launching state. We know that IP rights, that are anything that's developed within that element of the ISS, belongs to that element. So we know personal property, chattel, there is personal property protection within space. So the question becomes, now, what about those resources? How does that apply to resources? Well, it's pretty clear through both property rights law and through international law that mineral resources, extracted resources, terrestrially, oil, gas, gold, silver, whatever, that becomes personal property once that's extracted from the land property. We know that occurs. And the same thing would apply in outer space. So even more so when you're looking at chattel or movable property, let's say asteroids. Asteroids are movable, they're not land property. Asteroids in and of themselves are personal property. The extracted material from the asteroids is certainly personal property. So the question is, what about on-surface operations? Well, on-surface operations, like terrestrially, could be or are personal property. So, to give you a long answer and really come back, we understand that personal property is allowable. The question is, will we codify it and clear it up once and for all?
Thank you, Sagi. And we're going to turn now to Barron. Barron, what's your take on this first issue, that of personal property, extracted resources? Is it clear enough that that's owned by the companies? Shouldn't there be no controversy about that particular provision in the Asteroids Act of Representative Posey?
Sure. Well, first of all, let me make sure you can hear me clearly and that you're not getting any feedback.
We can hear you loud and clear and perfectly.
Great. Well, I'm sorry I couldn't be there this year in person. But this is exciting because last year when we had this panel discussion, we talked theoretically about having legislation introduced, and now we actually have it, and we can talk about a real-world example. And my short take on that is I think it's a great start. It leaves a lot of unanswered questions that will have to be resolved before it's going to go anywhere. But let me start with the legal issue that was mentioned, just to clarify things. So the point that was made about how the Outer Space Treaty certainly contemplates use of space in Article 1 is absolutely true. That's exactly the right place to begin this conversation, and it's not an accident that that is Article 1. That's what the Outer Space Treaty is for. Article 2 is certainly what complicates the conversation. It says that outer space is not subject to national appropriation. And the way that I often like to frame that to people is that that Article 2 is really what stops the United States, or for that matter, any other country, from growing into space. That's what means that we're not going to have the 51st state on the moon, and we're not going to have national governments extended. And I actually happen to think that's a good thing in the long-term future of the species. But the question then is, what kind of property rights do you get out of that? And I want to clarify just one small detail that becomes, I think, a little bit important here. Article 8 does indeed confirm that objects in space are not affected, their ownership is not affected by being in space. But the definition there, what it's referring to is rather narrower than general personal property. It very specifically says that it's vehicles and facilities launched into space, their component parts, things that are built in space. Those are owned just as they would be on Earth. And that's why your space station, your spaceship, anything you build there is yours. That's not in dispute. Nobody would ever claim otherwise. The hard question is, what about other things? What about extracted resources? And I wasn't entirely clear from what was just said, but to the extent that it was suggested that Article 8 is what covers extracted resources, I don't think that's exactly accurate. I don't think that they qualify as objects on a registry under Article 8, unless they're turned into a vehicle. So if you extract minerals and you build a spacecraft out of that, that's clearly covered by Article 8. So the question is, what do you do with extracted objects? And I certainly agree with the general point that was made that that those things are owned, and we know that from the precedent of the moon rocks. The United States and the Soviet Union went to the moon, brought back samples, have possessed them and treated them as personal property, have gifted them, and those things have been resold on the international market. There are some space lawyers who will quibble and who will claim that doesn't mean that those things can actually be owned in the way that they can be on Earth. But I don't think that that's the correct view, and I think it's certainly a good idea to confirm that the United States interprets the treaty to mean, separate and apart from, but consistent with Article 8, that's a form of property that we recognize. So that's the most basic level. So you have two things there. You have the treaty itself says you have a base, you have a vehicle, you own it, and then what I would claim is customary international law says if you extract resources, you can own those too, even though the treaty doesn't explicitly say that. The next step then is that what the treaty does explicitly give you is a right to peaceful use of space on a non-interference basis. And that is essentially a kind of property right. That says if you're doing something, nobody else can come in and stop you from doing that unless you're harming somebody else. And that is essentially how radio spectrum works. We have functional property rights in the spectrum that delivers you television as well as your mobile broadband and your cell phone signals. on exactly that basis, non-interference. And so you put those things together, and what that gets you is you're running a base, you have a right to continue operating it, you have functional property rights around it, even though they haven't been recognized yet by statute. And I would say under the Moon Rocks precedent, you own what you extract. And then this is where I'll stop. Then the question is, so what do you do about asteroids? And I agree that asteroids are movable, and that asteroids are, in that sense, essentially in practice, no different from a rock that you might remove from the surface, and that we should essentially treat them the same way. And I think this legislation goes in that direction, but it doesn't actually, if you look at it, it doesn't connect the dots. And the key way to think about this is the legislation, which I think is a first draft, really, of what I hope will ultimately get passed. The one very obvious definition that's missing is the definition of asteroid. And by not defining that, it leaves that ambiguous. And if this were to pass, that ambiguity could be resolved by the FAA. But it's probably going to be necessary to do it in statute, and it's probably going to be along exactly these lines. And the basic point here is the difference between an asteroid and the moon, or between an asteroid and Mars, is you can't move Mars. And there are all sorts of ways in common law and in mining law, by extension, to establish a precedent that says if you can move it in a functional way so as to be able to gain beneficial use of it, then you can own it. And I think that's both consistent with international law and necessary for developing this industry. And I'll just add one thing in closing, which is the other thing that this bill doesn't exactly do is it doesn't really say that what it's proposing to do is what the U.S. thinks is consistent with international law. It's worded in a subtly different way, which is that the FAA shall go ahead and do these things consistent with international law, which sort of leaves open the question of where the lines are exactly. And I would just be a little concerned the way that this is drafted today, that would allow, if there are elements of the U.S. government, be it at the State Department or anywhere else, that were concerned about this, that they could really hold up implementation of this system because Congress didn't clearly lay out what it thought was consistent with international law and its findings, which are totally absent here. There's nothing in here about the views that Congress is taking of international law, and I think those would have to be added for this bill to achieve its purpose.
Thanks, Baron. So to wind up, Baron's already taken us a little bit into question two, the rights to surface and subsurface, but just to summarize, on extracted resources, Jim gives us the Apollo example, Baron and Sagi give us the Soviet examples. There really shouldn't be any controversy about that, and it would be good for Congress to so state in legislation, and even further state it's completely consistent with international obligations to have property rights, to just end the debate. By the way, the reason Sagi mentioned some of the stirrings that still go on, I'm not going to mention a particular treaty he just mentioned, because on my blog I mentioned I didn't want to talk about it because it's completely irrelevant. Its initials are MT, or I guess MA, if you want to. But the reason why some of this controversy stirs around is from the Orb Dev case, where they claimed property rights in an asteroid Eros, and then sent, because NASA sent something there, they sent an invoice to NASA, a parking or rental invoice in 2003. That led to the Brabanti letter, where basically the State Department in a very cursory letter said Article 2 prevents private property rights. Well, again, they weren't making the distinction between movable property and real or personal property on the one hand and real estate on the other. It also led to a board of directors of the International Institute of Space Law statement that also didn't make that distinction. But I have to believe even the ISL doesn't believe in that statement, at least as it applies to extracted resources anymore, because I've been in rooms where the question has been asked. There's been a lot of ISL members. Does anybody have a problem with property rights over extracted resources? 30, 40 people in the room, one hand goes up. So again, it shouldn't be controversial. We should end the discussion. It should be put in the bill clearly, and a statement should be put in that it's totally consistent with international obligations. So with that, let's move on to this. Again, Baron took us down this path already, rights to surface and subsurface now. If I land or build a mining operation on a lunar body or an asteroid, what prevents somebody else from saying, hey, that's a bunch of smart guys, they must have researched it, there must be something really good there, plopping down right next to me and doing the same thing? In other words, shouldn't there be at least a non-interference right, or do we need something broader, an actual real estate right? And here I'd bring up one recent example and one old example. So Bigelow Aerospace has a payload safety review request on a lunar habitat. And in that request, what they are asking is that the FAA also grant an operational zone. In other words, something that could be organic or variable depending on the activity, but some zone of exclusion where others couldn't plop down next to you. Also out there, it's been out there for a long time, is the Space Settlement Institute's broader proposal, proposed Space Settlement Act, where you would actually give to the first company 6,000 square mile swath of moon, 4% of the lunar surface, to the first one that has a permanently inhabited camp and regular transportation back and forth. So I'll turn to Sagi and then to Jim. What are your views on Bigelow's Aerospace's recent, I guess from December 2013, payload safety review request to FAA, or broader proposals from the Space Settlement Institute?
Yeah, I think it's a great idea, and I personally applaud Mr. Bigelow and Mike Gold, who represents Bigelow. He's done a fantastic job, because there has to be a clarification in terms of non-interference, right? We just talked about, it's fairly clear in the established regimes that we have so far, Outer Space Treaty, and even the International Space Station Act agreement, that that there is the right to non-interference. In fact, Article 9 of the Outer Space Treaty talks about it's not even implicit, there's an explicit regarding no harmful interference. So the question is, how do you codify that in terms of actual operations? Well, you know, we can look at, historically, we can look at other legislation that does that, right? We can look at the Law of the Sea. The Law of the Sea gives you a 58,000 square kilometer space that once you get your license, you know that there's no harmful interference by any competing company. That's going to be critical to any company and investors that are putting time and money. The very fact that Bigelow brought this to our attention means that this is a concern. This is a concern to the industry. I applaud the Asteroids Act for specifically talking about no harmful interference. I mean, there's an explicit clause in there. My concern, and just like Barron said, that he's got a little bit of a concern in terms of how do you define an asteroid, right, regarding the whole celestial body or not celestial body. I would even add to that, there's a concern of when does non-interference apply? When does it start applying based on the type of operations that you're doing? What do I mean by that? It's pretty, and Jim, maybe you can, you probably know this a little bit better than I do, looking at this legislation. It's pretty clear in the clauses. It's actually a little conspicuous in the clauses in the Asteroids Act that it talks about facilitating the exploration and use of resources. It talks about no harmful interference from the exploration and use. It goes on to talk about exploration and use. When it comes to the definition of what a commercial asteroid resource mining company is, it says either exploration or utilization. In my eyes, that leaves a gaping hole here in terms of when does non-interference apply and when does first in time apply. What do I mean by that? Does Dennis Hope or Nemitz, I forgot what his first name, Greg Nemitz, are they now going to claim first in time to Eros again, or Nemitz is going to claim first in time to Eros by setting up a high-powered telescope and saying, well, you know what, under the definition of the Asteroids Act, I'm exploring utilization of asteroids, and therefore there could be no harmful interference in that on that asteroid. So there are some gaping holes to a very thin legislation, but it's critical that that's flushed out in terms of what's first in time, and what's and when, and what's the zone of this non-interference in terms of the difference between on-surface operations. Is it a exclusive economic zone like we have in the law of the sea for 200 miles, or is it something less? When you claim to utilize an asteroid, do you have that non-interference for the entire asteroid, or depending on the size of the asteroid, do you also have an exclusive economic zone? So there are critical questions that have to be flushed out, that if they're not, the opportunity that's been handed to us with this Asteroids Act of really taking it a step further to bringing investors, opening up space settlements, realizing the dream that we're all here, that brought us all together, our passion, could actually fall apart.
What are your thoughts on this non-interference principle, or whether there needs to be something greater in actually surface and subsurface property rights in the Bigelow Payload Safety Review request?
I'm a little nervous here, since I am definitely not an attorney, but my sense is that if asteroids are in fact movable and therefore chattel, and therefore personal property, Baron, you had a different term for it, then you don't need to address those issues for asteroids per se, and you have to address the issues with lunar and other planetary celestial bodies when you decide you're going to deal with celestial bodies in legislation or a regime or whatever. The Bigelow request is interesting. It applies a regulation that the Federal Aviation Administration created to protect the space station or other space stations in Earth orbit from interference, and they're basically saying that should apply to a base on the moon, and therefore should effectively create a zone of exclusion. If somebody wants that, I think that's going to end up having to be done on a statutory basis. I don't think you're going to get there just by interpreting the treaty and domestic policy. There's got to be something. Either there has to be a federal agency given jurisdiction over those sorts of activities, over the flight between Earth orbit and the surface of the moon, over the transportation phase, and over transportation on the moon, or something. So that there's otherwise there's too many levels of assumptions going on that you can just say, yea, verily, because the treaty says non-interference, we should be able to create that on the moon and exercise that on the moon. And it brings up thwarting issues, okay? Like, well, does there need to be somebody in charge, okay? And I won't go into the details, but those issues are in discussion in Washington right now, and there are parts of the U.S. government who believe that if no one in the government is in charge, that means you're not allowed to do it. And that's a really bad idea, to allow that assumption to gain any currency.
So can I jump in here?
Please do, Baron.
So let's just start with that last point. So this is kind of the critical point. I'm the sort of person who believes that in general that which the law does not forbid is permitted. And that is essentially the basis for Anglo-Saxon law, which is the opposite of the continental tradition, which says that, unless the law authorizes it, you can't do it. The question, though, is Article 6 of the Outer Space Treaty does make states responsible for, and I'll just quote briefly, for assuring that national activities, which includes the activities done by their citizens, are carried out in conformity with the provisions of the treaty. And so the question is, what does that mean? So one way to fulfill that obligation, to tie together this conversation and the conversation about on-orbit regulation, one way to fulfill that obligation that the United States has was passing the Commercial Space Launch Act back in 1984. That is a system for licensing, launch, and reentry, and ensuring that the FAA reviews every single launch, both to make sure that it's safe and to make sure that it's conducted in conformance with the treaty. But that's not the only way to run a system, right? We have all sorts of ways of supervising activities in the rest of the economy that don't require that kind of licensing. So my answer on both this question of on-orbit activity and of mining and so on is that the United States does have to supply law here at some point to properly regulate activities and make sure that they're conducted in conformance with the treaty, but that we can and we should do that in the way that is most consistent with the tradition of common law that we have in this country, which means both property rights and tort law. And tort law is generally how we resolve problems of interference between and among parties. So that's a long way of saying that anytime you have multiple actors working in an environment, they're going to come into conflict. And you need a way of resolving that. And the Outer Space Treaty has essentially three goals that are somewhat in tension that we need to resolve. So one is that we've already discussed, the peaceful use slash non-interference, right? Those are flip sides of the same coin. Second is a general idea that we don't want territorial appropriation. We don't want, and I think rightly so, we don't want land grabs. You don't want the United States, just because it was first on the moon, being able to say, well, that's it, it's ours, and nobody else can have it. And those things are on the margin somewhat in tension, because the problem with this, with any conversation about this topic, is that if you don't do it well, if you don't really think through what you're doing and you don't present it in a way that's sensitive to those two concerns, and the third concern about national supervision, you're going to get a backlash from the international community. So the worst case scenario is someone rushes forward with legislation that is unfinished, and the rest of the world thinks that what it effectively means is that U.S. companies will be monopolizing, whether it's Shackleton Crater or key asteroids or whatever. That is the kind of concern that drove the Moon Treaty, and that might be likely to revive it. So then the question is, how do you avoid that? How do you fine-tune legislation like this to make sure that we really are doing this in a fashion that's consistent with the Outer Space Treaty? And to get back to what Jim and others were saying, on the most basic level, you can't talk about rights in the surface. That's not the issue here. The right is to peaceful use, right? And if you maintain that distinction, I think you avoid a lot of the problems that people in the past have raised about effective territorial appropriation. So just to give you two examples, if the U.S. says you have a 2-kilometer non-interference or safety zone around your base, that is very hard to argue against under the Outer Space Treaty, because that's a pretty straightforward implementation of Article 9, the non-interference principle. On the other hand, if the U.S. says you have a permanent right to all the land that you ever own on, and then it's yours once you get there, and even after you leave, you still own it and you can sell it, that's very different. And it's also very different if that's 200 miles or if it's 2,000 miles. And the question is, how far can you reasonably extend that non-interference principle? And the question that I think was being asked here was really, it's really a question not about extraction of objects, um, but really about mining claims. Because mining claims are a different kind of non-interference use. It's saying, I'm not necessarily physically occupying the immediate surroundings of my base. It's I've staked out this particular area and I'm planning to use it, and I have a limited amount of time to perfect my rights under law, right? And that's what mining law in this country typically has done in the past. And that's what, importantly, the Deep Seabed Hard Mineral Resources Act did back in the late 1970s, when it became clear that the Law of the Sea Treaty was going to turn into a very socialist system where the United Nations was essentially going to be running deep seabed mining. Democrat from Louisiana, John Breaux, in the United States Senate, put forward a bill that is still part of U.S. law that authorizes the U.S. to issue only one license to a private company from the U.S. or from any other country that has legislation that we have recognized as being compatible with ours. Only one license would be issued to that area. And that, to make a long story short, is a way of recognizing functional mining claims without either the U.S. appropriating that territory or with the private company having permanent rights in that land, because it's essentially a system of recognizing just a claim to explore that area and to mine it for a particular period of time. That's worth exploring, and that maybe, as Jim said, that's probably the only way you get something like this to work on the surface. And then you have the question of, can you justify, on the theory that we were discussing earlier, something beyond that for ownership of an entire asteroid? And we don't need to unpack this now fully, but I'll just suggest that some of this should be done in legislation. A lot of this gets done over time through development of case law and developing standards and principles that courts use to weigh these matters. But if it's going to be done here, it has to be clear from the outset that the U.S. is not doing an end run around the treaty to allow people to appropriate territory and space in the way that's prohibited by Article 2.
Baron, just to summarize here on the surface and subsurface issues, one thing all of you can tell right off the bat, this is a mix of law, policy, politics, and diplomacy, right? You can't really do space law without knowing the politics, policy, and diplomacy. You can't do space policy without knowing the law, the policy, and the diplomacy. And so that's why I'm always chuckle a little bit. You know, Jim says he's not a lawyer. Well, okay, Patty Grace Smith says she's not a lawyer. Mike Simpson says he's not a lawyer, but they're pretty good lawyers because you have to do the entire mix. They all interweave. Wanted to also summarize.
I assure you, no one's ever called me a diplomat.
Also want to summarize these tensions in the OST. There's freedom of exploration and use in the OST, but there's also, you're entitled to free access to all areas of celestial bodies. Those are kind of in tension, right? Because if I start exploring and using, does that mean somebody can come and say, but I get free access to all areas of the celestial body? No. You can't read one right to totally defeat the other. The other tension that's been mentioned is Article 2, you can't appropriate property, but Article 9, other countries have to show due regard. And if they're going to do something that would potentially cause harmful interference with you, they have to consult in advance. It's sort of a non-interference principle has been stated. So these things have to be read in conjunction. The other thing that came out in the discussion is these lines that we have to draw, and whether they're better to draw in legislation or regulation or just through practice, right? How much activity do you have to do to get a non-interference right? You know, the telescope, landing something there, actually starting to extract resources or inhabit with people. So that's one line that has to be drawn. And when it comes to asteroids, same thing. Where do we draw the line? How much do you have to do? How much do you have to move that asteroid? Is just moving it 100 meters enough, and now that asteroid's yours, or do you have to move it into a commercially valuable or commercially viable position? So those are issues that are going to have to be resolved, and probably it's going to be tough to draw those lines in legislation.
Can I just jump in there, Matt? You
Sure.
reminded me of the other thing that I was going to say, which is this idea that you have a non-interference right because you're pointing a telescope at something, or because you were the first to go claim it in the California County Land Office is absurd. And quite frankly, Greg Nemitz and Dennis Hope are charlatans who have done more to discredit the concept of space property rights and cause the unnecessary alarm by the international space law community than anyone. They have done an enormous disservice to this cause. So I think it's really important just from the outset to be crystal clear as a legal matter that what the Outer Space Treaty recognizes when I talk about non-interference is if you're there and you're conducting ongoing operations, other parties can't interfere with you. So let's please just take them off the table and talk about serious companies doing serious things.
Well, actually, if I can jump in just for 1 second, I totally agree with Baron, and I think that was my point. That was the one extreme. What about that middle ground between what I was talking about before, between Dennis Hope on the ground here terrestrially staking a claim, which is completely ridiculous, and a company that is now sending satellites or some spacecraft to circle around the asteroid and claim it as its own, but it doesn't actually have possession of the asteroid, right? Because I was talking about that little bit of that hole in the Asteroids Act that needs to be filled in, that gap that talks about exploration or utilization. Is it enough for a company to send a spacecraft right near the asteroid and say, I am exploring at this point. I don't actually possess it, but I'm exploring, and therefore I should be granted the non-interference right because I'm first in time to circle around the asteroid. And we know that generally, both in international law and customary property law, that you actually need to mix the labor with the land. And here it's a little bit of an oxymoron, right? Because we're talking about personal property, it's not really land. But it could be for any property. There actually has to have some type of possession. And I think that we shouldn't wait for case law, because then it might be a little bit too late, that we need to codify what is utilization, what is possession. And I would say there's actually three things that we need to talk about here, right? That's been discussed before. Number one, you need to have some kind of telepresence, right? Telepresence is, you have to have some visual contact with that, let's say, call it asteroid, call it a comet. We're talking about on orbit right now. So you need to have some kind of telepresence. That's number one. Number two, you need some type of telemetry. And telemetry is constant communication with that object, and you can track it, which actually would be required under Article 6 of the Outer Space Treaty, where the nation that authorizes that private entity has to make sure that it's continually supervising that entity. And telemetry and having constant tracking and knowledge of that asteroid could fall in line with meeting our obligations under that. And the last point is there has to be some kind of telerobotics, some kind of possession or manipulation of the asteroid. Now, what is that going to look like? Does that mean that we have to start taking soil samples from the asteroid to say, okay, now you've got possession and you are protected from non-interference under the Asteroids Act? Is it actually grabbing onto the asteroid, moving it a little bit? Whatever it may be, I believe that if we leave that hole of uncertainty of what is now possession of the asteroid, we are going to run into a lot of trouble that we shouldn't wait until case law. That needs to be codified as soon as possible in the Asteroids Act.
So I couldn't agree with that more. I'll just say that this is, again, what U.S. mining law has long done. Mining law doesn't just mean you go and you say, I'm going to mine this area and you're done. You've got to meet certain requirements, just exactly as was just laid out. as to what constitutes the minimum level of effort that's needed to stake your claim, and then you have a limited time in which to perfect your claim. So you've got to, having done the things that were just mentioned, you've got to actually then go out and start mining it or move it within a certain period of time. And if you don't, you lose your claim and someone else can take it. I totally agree that that's the kind of thing that should be staked out in legislation and then developed over time through a mix of regulations that implement the statute, and then inevitably, eventually, when we're lucky enough to have two companies that are competing with each other and they're chasing claims, there are going to be conflicts, and those will be worked out in adjudication that will form a common law over time.
So the final issue, and it's been raised in the discussion already, I want to get to before we turn to audience questions, and these are related. This notion of on-orbit jurisdiction. So right now, FAA has authority to regulate launches and reentries, licensed launches and reentries, but not expressly ability to regulate on-orbit activity. And that's why Bigelow, one thing FAA has to do, though, for a launch license is do a safety review on payloads. So Bigelow is trying to use that vehicle to actually get the FAA to allocate this zone of operation. But the question becomes, does Congress need to grant express on-orbit authority to FAA? Should it be FAA that gets it? And connected with this is something that was also raised. The U.S. does have an obligation under the OST, Article 6, to authorize and continually supervise its non-governmental activities, its commercial activities in outer space. And so the question is, what does continually supervise mean or require? And would it be easier to meet that obligation if the FAA or some other agency within the U.S. government had on-orbit authority? To further throw a few other things in the mix, keep in mind the FCC licenses commercial communications satellite operations and does impose debris mitigation requirements, which you might think of some on-orbit regulation. And NOAA, of course, licenses commercial remote sensing satellites. So let's turn first to Jim and then get Sagi and Barron to comment on that, and then we'll turn to audience questions. On-orbit jurisdiction.
Well, it's good you bring up the FCC because they certainly think they have on-orbit authority and authority for anything that receives or broadcasts electromagnetic waves. Hello? Okay. They think they have authority and jurisdiction over anything that receives or broadcasts electromagnetic waves from here to Alpha Centauri and probably beyond. But the question is AST already has, or rather the Secretary of Transportation already has, some inferred or implied jurisdiction over activities that are that we normally think of as going beyond the launch phase and beyond or before the reentry phase. There is a foreign policy interest in not running into the satellites of other governments. Okay, there is a because as the licensing state, the United States government is implicated in that. There is a national security interest in not running into DoD satellites. There is a the international partnership of the space station, the Bigelow safety approval policy review is based on the regulation that AST wrote to protect the ISS or other manned habitats from quote interference, and the FAA actually justifies that regulation with a fairly interesting rule, argument that they make. They say is, well, we're protecting innocent third parties. Okay, in other words, we're using our statutory mandate to protect the general public in the statute. Now, last I checked, under the liability convention, people in space are not the same as people on the ground, and therefore, for the AST to interpret them as still members of the general public requiring the high level of care that the Secretary of Transportation is required to perform for members is a little frightening that they're applying that sort of thinking in space. It is a good idea for someone to lead at the policy level to figure out things like space debris and space traffic coordination and things like that. It would be nice if someone were to coordinate policy with an eye towards promoting, you know, the economic growth of all U.S. commercial space industry, okay? And I wouldn't want to give any federal agency much more authority than that. That's sort of the position of the Commercial Spaceflight Federation, that it should be a promotional-based role and it should be at the level of policy and coordination. Every time I hear someone say space traffic management, I start to break out in a rash. As long as the commercial space launch licensing function is buried inside the FAA, with the incredibly great functioning air traffic control system in our country, I think, well, space traffic control, air traffic control, we'll just have those people work on it, in which case we're dead. So there's also the useful precedent of the Space Data Association as a private entity that has gone out and basically, I don't want to say that they've privatized space traffic coordination, but they have in fact created a natural public service where they interface with the government, you know, and provide a level of shielding of what the government's doing, various government assets, but make it very easy for anyone in the private community to find out if they're going to move something, it's going to cause a problem. And so that there's some really interesting ideas there, which is one reason why an executive agency should only have to, do anything at the policy level and promotional level, is because there's already a natural solution to the actual management issue happening in the private marketplace.
Yeah, I'm just going to jump in really quickly. I don't think there's really that much more that I could add that Jim already stated. I agree with him 100%. We've got to be very careful that with a nascent industry, we don't start over-regulating and killing with too many codifications, too many authorities getting involved. Look, let's just look at it practically. Where are we right now, right? I mean, we don't have Anakin Skywalker flying in and out of the terrestrial area there's 30,000 spaceships and mining companies. We're not at that stage at all. We're not even close to that stage. So we don't need it now. I think Jim is right. It's a certain amount of policy that we need, but we've got to tread carefully and follow the heart and intent of the Asteroids Act, where there are no government barriers, or we make sure that there are no government barriers that inhibit the exploration and use. And over-regulating is going to go exactly against the intent of this bill.
Baron, final thoughts on on-orbit jurisdiction, and then we'll turn to the audience.
Yeah, well, as a professional libertarian, I'm totally against over-regulating industries. But on the other hand, there's prescriptive regulation, and then there's having a clear legal framework. And the General Mining Law of 1872, for example, which is still how we do mining law in the U.S., lays out a clear legal framework that explains how you get mining rights. And so those are, you can imagine a system like that is implemented as regulations that are not the kind of regulation that kills industry, but rather the simple rules that lay out how you actually effectively make use of your rights, consistent with the Outer Space Treaty. So it's just unfortunately we don't have clearly different words for those two things, and the difference between micromanaging how companies work versus enabling them to go forward and thrive. And in that confusion, lies a lot of the mischief that, that regulators often use for cover to excuse what turns out to be micromanagement that is disguised as being pro-business. So I just leave
Baron,
it
I'm
at
going
that.
to stop you there because we're down to about 5 minutes for audience questions because we started a bit late and I want to make sure we get to them. So, yes, over here.
Yeah, a couple issues I'd like to raise that may merit some attention. One is there are other things in the treaties that get involved that may affect what this bill and other activities end up doing. One is if any mining activity is manned, there is this thing about in the Outer Space Treaty about astronauts from one nation, signatory will provide all possible assistance to others. Okay, that will complicate any long-term things that involve manned activities. The second is this moving objects as a basis for deciding whether they're celestial or not and fall under the, can't be owned and appropriated. Archimedes said, give me a place to stand and I can move the earth, okay? But when you say, well, how much do I have to move it? You get into a really messy issue, which is that the most valuable objects to mine are the near-Earth objects, asteroids and comets, that have the lowest delta V to reach the Earth. And if the U.S. government approves your mission, they are taking on the liability for your accidentally redirecting this asteroid to hit the Earth. And that gets into some really messy, how do you get approval of a mission that could do that accidentally? And the third thing, which actually ends up being a possible benefit, is if in the process of doing any preliminary exploration, you place a transponder, a long-lived transponder in an object, that is of substantial benefit to all mankind because it allows you to measure the orbit more accurately, predict its orbit more accurately, and know whether or not it's a problem that needs to be dealt with to protect Earth. So these things will affect the decision processes and maybe the wording of the law.
Issues.
Well, how about I jump to the second issue regarding celestial bodies and the size of the asteroids. It's a good question. There is no definition of what a celestial body is right now, right? We know that. One possible place to start is certainly you have all these near-Earth objects. You have asteroids of 1 meter long to 10,000 meters long, right? They're pretty large. One possible place to start is saying that is using the definition of hydrostatic equilibrium, right? If you've got an object that has enough mass that makes it spherical, such as Ceres, which is an asteroid, but say that's a celestial body, you can start there in order to start putting some kind of roadmap. That has to be created, but I think there are possible easy solutions for that.
Next question.
Yeah, I would contend that probably just flying it around and looking at it is not sufficient to say, hey, everybody else, back off, I'm a scientist. Because I can do that. If all you're doing is just looking at photons, reflected photons from it, I can do that from my backyard. I would think you probably, in order to really say, hey, this is mine not for property purpose, but at least for not interfering with me, there probably ought to be some, atomic level interactions with the thing. You hit it with a grapple or do something, but I think there should be some physical activity taking place.
Well, the question is whether or not the Asteroids Act as legislation really makes that distinction. I mean, one thing while we were sitting here, I was looking through the bill again, because what it talks about is an interference with exploration and utilization. Well, if you're only exploring, okay, which could be with photons from a kilometer away, does that only give you a right to non-interference with your exploration? Or does that also give you a right to non-interference with utilization? Okay? And of course, the bill doesn't really get into that level of detail. And I wouldn't presume to guess whether, where the treaties or other framework issues would come down on that. Yeah. But, I would argue, no. it shouldn't you shouldn't automatically get on on a boat and have the right to certain things associated with the end of the voyage just because you got on the boat, okay, in the harbor, okay, especially if the boat's tied up.
Yeah, well,
So-
I would argue the useful precedent is you're doing an aerial survey of some place to look for a mine, as opposed to your boots are on the ground.
Just for 1 second, I think that U.S. courts have already looked at this when they looked at salvage claims, right? So when someone's looking to profit off of a salvage, the courts have deemed that you can have telepresence there, but you have to have something on the bottom of the ocean that's at or near that vessel that shows that you've got possession. So you've got to be there, actually on the land or actually possessing the actual object.
Final question. By the way, for those of you still having questions, feel free to come up
Yeah.
to the panel afterwards.
A couple of things. The bill should at least say comets and asteroids, because a lot of NEOs are probably extinct comets. But one concept that hasn't been used here, which I think would be helpful, is the idea of an ore body. You can't profitably mine something unless you characterize the ore body. That is a part of exploring. And what we really want to do in the law is anybody who spends significant resources characterizing an ore body should have at least temporary rights to exploitation. But if they put out trivial amounts of efforts, for instance, pointing a telescope at something, they should not have any sort of permanent rights. And that basic idea of characterizing the ore body, I think, will simplify the thinking about this. But maybe I'm wrong.
I really like that point, and it's just another way of saying what I was saying earlier, which is that mining law is all about giving people an incentive, just like with patents, right? The term patents today is actually also used for mining claims historically. And the point is exactly what was just described. Give someone an incentive to do initial work in identifying something of value, and then give them, it's not technically a right in that object, it's just that you have, for a short time period, you're the only one that's allowed to take the next logical step so that others don't free ride off the work that you've done. So let's just be careful about not characterizing that as a right in the object, and keep in mind that what's being proposed is consistent with the Deep Seabed Hard Mineral Resources Act, which is a way of doing mining claims without territorial appropriation on the seabed floor.
Well, please join me in thanking the panel.